So Allied Legal is a commercial law firm that works closely with startups, founders, and growing businesses. The team provides practical legal advice across areas including intellectual property, fundraising, commercial agreements, and business growth, helping founders navigate legal challenges with confidence. Rahul Kumar is the founder of Allied Legal and a seasoned corporate lawyer with over 20 years of experience advising on complex corporate law matters. A recognized specialist in the startup and scale-up space, Rahul has a deep understanding of the legal and commercial challenges faced by high-growth businesses. Having worked at both national and international firms, his expertise spans corporate structuring, capital raising, shareholder arrangements, mergers and acquisitions, and strategic governance. Through Allied Legal, he continues to shape conversations around innovation, supporting ambitious founders and investors as they build and scale companies. So please help me welcome Rahul.
Fantastic. Hi all. Firstly, thank you to the StartSpace team, Amir and Shireen, for having us here today. I think what they do is fantastic and it's an amazing space. Thanks for the coffee, the breakfast, and thank you all for attending. So today we'll talk about legal essentials that startups should be aware of, right? And I think as part of the process of presenting, you will get to know more about us and the services we provide. That's our wonderful team. Sam is here today, so if you want to say hello to him later and have any questions, feel free to reach out to him as well. In terms of what we do, so we work with startups across industry and across life cycle, right? So from early stage all the way through to when they scale and expand and through to an exit. We've got unicorns on our client base. We've got a couple of founders and an idea on our client base and everything in between. So today we will touch upon a bunch of stuff and I'll rattle through it and feel free to ask questions. I'm happy to keep it interactive. We'll touch upon structuring and getting the right structure up in place, building your team, key agreements, founder disputes, and oppressive conduct. Unfortunately, we do a disproportionate amount of work on founder disputes, and there are ways and means to avoid them and ensure that that doesn't happen. So we will touch upon founder disputes, intellectual property, so IP and commercialization, and then funding your startup. So we normally have a presentation that's just on startup funding, which is normally very well received, but I'll quickly glaze over it today. And that really does cover off on a lot of what we do in our day-to-day when we work with founders. So first and foremost, let's talk about the types of business structure. And as I say, I'll rattle through this a little bit and given the amount of time we have today. I think for purposes of this audience and to the extent you're looking to set up a business, I think it's, as a general rule of thumb, a company structure, a proprietary limited company structure in Australia is the most appropriate structure when establishing a new venture or a business. Now, there may be obviously times when you might look at a partnership or a trust, depending on maybe if you're in the professional services space, but generally speaking, a corporate company structure is what you're looking to do. And the reason for that is it protects you and your personal liability, right? A company is its own separate legal entity, and that's the reason you look to set up a company structure. The other reason is as you grow and scale and you look to bring on investors, you can't issue shares in yourself, but you have to give ownership up. So companies, you can issue shares to investors and by that way divvy up ownership. The other issue is your intellectual property and the assets you're creating. If you're a group of founders all working together, you need a place to house them. So that company is the vehicle in which everything should be assigned, and that's where ownership rests in your company. And to be honest, it's just a basic requirement that any investor would expect you to have. What else? The one thing I will mention is there is absolutely a place for trusts in the way you hold the shares in the company, right? Unfortunately, the recent budget announcements do mean that the value of that trust holding shares in a company has been somewhat diminished, but it's probably for another time. But the point is that generally speaking, we have our founders setting up a family trust which holds shares in a company, and that's for tax planning purposes. So thereafter, let's talk about building your team, and this is something that we do advise on a fair bit, as you'll imagine. Now, in the startup landscape, it's hard for you to pay market rates and market salaries. So how do you incentivize and bring on the best talent and grow a team? And so there are employee share and option plans that are available specifically to startups. And what that allows you to do is issue equity, that's ownership in your company, to those that you're looking to attract and bring on in a tax-effective manner, right? So you make offers to individual recipients. It might be a tech developer or a salesperson or whatever it may be that you're looking to bring on. You can't incentivize them, obviously, by paying a market salary, but you can incentivize them with ownership and coming on the journey with you. And one thing I will mention about, I think while we obviously provide legal services, a lot of what we do spend time with our clients on is getting them informed about market norms. So, how much should I be issuing to X person or Y person? How should I be structuring this up? What are market norms when it comes to issuing shares or issuing options? And that, I think, working in the sector as a startup specialist, I think it's an intangible value add. In terms of employees or contractors, so we have seen, in Australia, there are employees are regarded, employees are protected with things like unfair dismissal. You have annual leave entitlements, superannuation payments, etc., etc. Whereas a contractor is someone who essentially is carrying on a business on their own, right? So so for example, if you're engaging a software developer, for a one-off project, they're likely to be a contractor. Whereas if you've got someone that's helping you on a day-to-day basis, where they're taking instructions from you, right, and you dictate how they work and the hours they work, they're likely to be an employee. Just be mindful on what basis you're taking someone on board, right? How you're engaging with them. It's a substance over form thing, which means even though you might think that they're a contractor, it really matters how they're regarded under law, right? And we see this play out in reality quite a bit with clients where you'll start off happy, you'll bring someone on, they're helping you, relationship sour, and 2 years on, you've got this person who's asking for all sorts of employment entitlements, and it can become quite an issue. So just be mindful of that. There are other share vesting arrangements that we put in place to help founders bring talent on board as well, but I think for now we'll leave it at that. Key agreements. So in terms of the initial key agreements, as you're looking to set up a venture, say you're 3 founders, you're looking to do something in the health space, or we'll go with the health tech startup. We normally receive a call and they say, what do we need to know, right? So first and foremost, if we've touched on setting up a company, the second is, where is all the intellectual property? So if you're developing a platform, by way of example, which may be a marketplace to connect allied health practitioners with patients, we do a lot of that sort of stuff. You want to make sure that all the IP that has been developed, whether it's by a developer externally or internally, is owned by the company, and that's what. So we have what we call a deed of assignment, where we will assign all the intellectual property rights, right, from any individual that's working on the venture to the company, right? That's critical because you want to make sure that the company that you have set up owns all the IP. A shareholder agreement, it's fundamental. If you've got 2 to 3 people, 4 people, whatever it is, working together, and as you onboard investors, the shareholder agreement is critical. It's an agreement between the shareholders, as the name suggests, and it sets out the rights and obligations of all the shareholders as amongst themselves and of the directors of the company, right? So it gives a clear framework of how the company will be governed and run moving forward. And we spoke about, I touched on founder disputes at the start. If you've got a good shareholders agreement in place, should the proverbial hit the fan later on, it's the shareholders agreement. If it's well written, you should be able to go back to your shareholders agreement and figure out what happens in an event of dispute. But in any case, a shareholders agreement will set out things like how are key decisions to be made. You've got 3 of you that may be working on that are involved in a venture. what are the thresholds for passing certain key decisions? What happens if we want to introduce a new investor? What happens if one of the founders wants out, right? They've had enough, life changes, whatever it may be, they want out. What happens to their shares? So that's all set out. What else? I've spoken about employee and contractor arrangements. The only other thing I'd mention is your go-to-market documents as you get closer to getting to market, or to the extent anyone is looking to engage with your product or your service. That should always happen on the back of some agreement, whether it's basic or whether it's prepared by a lawyer. There needs to be an agreement whenever someone is utilizing your intellectual property, even if it's for testing, right? So we do a lot of work where we have startups that may engage with a university or a research institute to validate their product. Now, universities are notorious for having quite draconian intellectual property regimes in their what they call standard form contracts, where they essentially there is creep in terms of what they'll claim is their own intellectual property, where in the process of validating and testing your product. So you want to make sure that you are understanding quite correctly what you're getting yourselves involved into, because even though it's a university, it feels like a friendly counterparty to be engaging with. Just make sure you are you're on top of all of that. So that's key agreements. Founder disputes and oppressive conduct. The issue here is, look, we all start off at the outset to create a venture. Everyone's excited, happy. We may have certain life arrangements which makes it possible for us to dedicate a lot of time to a startup, and then 2 to 3 years later, and this happens a lot in practice, we see someone might have a child, someone might be looking to move overseas, someone might just be burnt out, right? And they don't want to be involved in the startup anymore. Or there might just no longer be a meeting of minds between the founders, right? You expected, X person to be doing a lot more than they are, and so there are disputes that arise. And the issue here is how do you avoid them? So firstly, have a clear framework, which again comes down to your shareholders agreement at the start, which sets out what are your expectations of each other, right? So if you've got a founders agreement or a shareholders agreement, that clearly sets out what your expectations are each other. Even if the relationship sours, at least you've got something to go back to. And that's why that agreement is key. The other thing that you need to keep in mind is there are laws in Australia against what's called oppressive conduct. So as a shareholder or director of a company, you must treat the other shareholders and directors, other shareholders of the company, in a fair and reasonable manner, right? You can't treat them oppressively, in an oppressive manner. And so what that means is, if you are, because it's a startup and you're used to sort of calling all the shots, and how the money is spent and how decisions are made, when a relationship starts to go the wrong way, you need to keep in mind that you can't now start excluding your co-founder from things like access to files or information or decisions or anything like because they are also a shareholder. So and that can be held against you if you start doing things at their expense. So to the extent that you do have these scenarios start to bubble up where you are no longer seeing eye to eye with the founder, I would strongly recommend that you either through a mentor or someone who you both trust, or to the extent required, a legal advisor, look to mediate that in a way that makes commercial sense. Because, as I said, we do assist founders with negotiated settlements and the like, but it's probably the least favorite of the work we do, because it's throwing good money after bad, right? So if you can look to use the common sense approach, don't start excluding one, don't start making decisions which would have otherwise been jointly made, don't start keeping information from them, etc., while you're looking to resolve a founder dispute. IP, okay. Let's talk about intellectual property. So with the kind of work we do, intellectual property is obviously at the backbone of our clientele, and in terms of the asset that they are creating, right? So in terms of IP, it's a broad topic, and I just want to make sure I'm covering off on. Yeah. So the example I like to give is if you think about the iPhone. So you can buy an iPhone, for example, for $1,000. I don't know what they cost retail these days, $1,500, right? And I might own an iPhone, and I can sell the iPhone, and I can do with it what I want. But it is the IP that is far more complex. It's the software, the hardware, the way the phone is assembled. These are all distinct parcels of intellectual property that comprise an iPhone that makes Apple what it is today, right? So the point I'm trying to make is when you are working on an idea or a venture or a tech or a disruptive technology, you need to be mindful that you're capturing and you're aware of all the intellectual property that is being created as you go along, right? And IPs are bundles of rights, and these are intangible assets. And the owner of the IP, they have the right to reproduce it, distribute it, use it how they want. And it is this also means that and how you commercialize it is something that you need to think about, right? Because it can be licensed, it can be transferred, it can be assigned. So when we are downloading an app, for example, of the App Store, we are entering that tick the box that you do, which is a contract that we often prepare. That contract is making it clear that all you're getting is a right to use the IP, but all the intellectual property rights still vest in the owner, whoever created it. Right? So similarly, when you are when you have created something, you need to think about your go-to-market document, because that contract is critical, because it sets the framework on how you're letting the rest of the world use whatever it is that you have generated or created. In the absence of that, it can be you are risking someone else being able to utilize it in any way they see fit, right? And there's no legal framework. So we often get asked very often, hey, I found this thing off the internet, or I've created this using AI, and we get asked, like, is that okay? Well, the point with using sort of documents you find online, I do think there's a place for it. By the way, I think in early stages, I appreciate that resources, especially financial resources, are limited. But as you start to get momentum, you validate your product, you're starting to get closer to market, you need to be thinking about the right legal advice. And I do think you need to have a budget for legal if you're looking to set up a venture properly. And so my point is, those terms and conditions that people, I think, blindly think, oh, it's just my T's and C's, it's critical, because that is the formal engagement or relationship you have with your customers, and it's a way of protecting your IP. And there are different ways of protecting IP, and certain IP is created, or the form of IP. It's created as soon as, I guess, you produce it. So, for example, copy. So if you write a poem or if you paint a picture, the copyright vests in the person who actually created it, and it makes a lot of sense when you're talking about a painting or a poem or a piece of literary work. But what about where you're talking about source code, right? So what happens with source code? So the point there is the source code is also a form of intellectual property that has been created by whoever has generated it, and you need to make sure that the developer, if it's an external party, is assigning their IP rights to your company. And we see this in practice happen quite a bit, where developers will use poorly drafted agreements, which they've had founders sign, right? And these agreements actually give the developers an unreasonable amount of clawback right, or say, or in the IP that they've created, and that is critical. That you don't sign agreements of that nature. We've got an example of that right now, where it's a health tech startup. They're actually getting fairly close to market, but they've signed, unfortunately, a software development agreement at the outset when they just thought they had a trusting counterparty. They've signed a software development agreement where the developer is now suggesting that these guys don't have the ability to just go to market and utilize the IP as they wish to, and they can't commercialize it. It's a major issue. So make sure any development agreement, at least vet the IP clauses to make sure that, generally speaking, 9 out of 10 developers do the right thing. They should just be vesting the IP or assigning it across to you. And this is the same thing goes for international developers, because a lot of our clients now use overseas developers. It's cheaper, but the same thing goes for them. You need to make sure that the agreements you're signing with them, right, vest the IP in your company. What else should we touch on? Beyond that, I think because I wanted to touch on the dual company structure. We do go into patents and trademarks and other forms of intellectual property, but given the time restrictions today, I'll move to other more practical means of protecting your IP. So in terms of structuring, this is a structure that we recommend all founders to adopt, right? So wherever, which is a holding company structure, and underneath it, you have an operating entity. And the point is that that holding company will hold all your intellectual property assets and other material assets. So any technology that you've created or anything else of value is at the holdco level. Below it, you create a trading company, which is just a shell company, really. And it is this trading company that enters into all your risky arrangements with your suppliers, your employees, your customers, etc. And the point there is, it is this company that is always at risk, right? Because if anything ever goes wrong, this is the entity that would get sued, and because it's got no value, even if it has to go under, it goes under, and all your assets are always protected at the top co level. So we're not sure. Yeah, sure.
In that structure, what does an investor look at? Are they looking at investing in the whole company, or are they looking to invest in the?
No, the investor will always look to invest at the holdco level, okay. And by virtue of that, they will also have an interest in the operating company. So this is 100% owned by the holding entity, and I'm not sharing anything. This is not rocket science. Any sort of competent lawyer should be advising you to do this. Yeah.
What are the pros and cons of having a holding company versus a trust to do that?
So the trust should hold the shares in the holdco. Yeah, we do see a lot of poor advice that is given, where you'll have two sister companies sitting next to each other. That should not be happening because, for the reason you've just mentioned, because an investor wants to hold shares at one level where they'll get a stake in everything, right? So if you've got two sister companies, it means every time you have a fundraising, you need to issue shares across. It's just it's a nonsense. That shouldn't be happening. But yeah, this is quite an easy thing to do. And so in terms of when do you do this, look, if you're just early stage, set up your holdco for now, get all your IP assigned, work on your venture as you please, get your R&Ds, tax incentives, all of that stuff. And then as you get closer to market, you can just set up an operating company underneath it. Yep.
Rather than going into the holding company, can I just sell the subsidiary, like the lower stage of the company? Does that make sense?
No, I mean, if someone is looking to purchase the technology, the app, well, that all the IP will rest there. So if you sell if all you do is sell the subsidiary, they won't be getting anything of value.
And the subsidiary cannot hold the IP, like you can't change the ownership of the IP?
Oh, I mean, you can. But so if you're assigning the IP across and then selling the subsidiary, yeah, you can do it that way. But just to be clear, there may be tax implications with assigning any asset of value. If by the time you're looking to sell a company, it obviously will have value. So that'll be an issue there, right? You can't. It's not that simple just to assign the IP across at that point. Yeah. Yeah. So I mean, we have clients, for example, that have done really well, and they might have a holdco, right? And then they have where they've got multiple ventures, and then they might have 3 or 4 subsidiaries. Yeah, and then each of the subsidiaries might hold intellectual property, but below that they'll have, again, operating entities. Does that make sense?
Yeah, it does. I don't want to go through like that. I just want to, so if Amazon buys one of my AR apps or whatever, they're
Yep.
going to sell 100 points of the subsidiary rather than giving them 10 points or 10% equity in the holding company. Is that legal?
Yeah, it's legal. They won't commercially. I don't see why they would do that though, because they will want an interest in the asset. I mean, I assume you're asking this question because you've got other things going at the holdco level.
Sorry?
I assume you're asking the question because you've got other things happening at the holdco level. Yeah. Yeah, and so that's where it becomes a problem. So it really, so that commingling of businesses at some point, if you are starting to get a bit of traction with both, you should be spinning them out to avoid this scenario. Yeah. No worries. Yeah. Yep.
Sorry, just a quick one. I assume like most of the startups, they don't have any agreements, nothing so far.
Yeah.
As just a startup.
Yeah, I get that.
What's the default law? Like if I create my base code, all right, what is the default? If I have the history of this code, it means I own the IP?
Yeah, if you've created it, yes, it does. The issue is if you're working with a co-founder and let's say she's created the code, right, and then you've got the two of you, you've created something, she's created something, then what happens?
Share it.
Yeah, you do, but the point is that in the event that you no longer want to work together, then now you've got this situation where it's not held in one place. So you're right, the default position is you both have intellectual property rights there, but I guess what we're trying to say is that if you're looking to create a venture together, you need to be assigning the IP rights to a company.
And let's say, okay, like,
So, I'm sorry?
We're just going to keep questions more towards the end because we still have a fair bit to go.
I will zoom through, but
We'll wrap it up, but we'll run the mic for questions. So
Yeah.
we're also recording the questions. Anyone online watching the recording can actually hear questions.
sure.
But yeah, would you like to?
Yeah, go for it. Yeah, I'll take one more question. Yeah.
I'm on your public domain API and just have a very quick question.
Yeah.
Is it possible to assign the operating right of a holding company to a smart contract? So right now legally, can the smart contract have legal presence in front of the law saying that only the smart contract has the right to decide to
I'll have to get back to you on that. We do advise on smart contracts, but there's a bit of complexity with that question. But I'll get your details and we'll chat. Yeah. So we do advise on smart contracts and the use of blockchain, et cetera, but it's a bit more complex. Yeah.
We'll have some networking a bit later.
Yeah.
We have specific questions that are very detailed about your own business, and you can also ask it afterwards.
Yeah, absolutely. So the only thing I wanted to touch on here in terms of go-to-market is just be aware that if you're, so we work across sort of the health sector, fintech, education, clean energy, we do a lot in mining. So all of these sectors have their sort of rules of it, rules to play, or if so to speak. And so as part of the due diligence you're doing for invalidating your product, which you should absolutely be doing, you also need to understand what are the licenses I need to operate. And it's really important to keep that in mind because the cost, for example, if you're looking to work in the financial services sector, we work with a lot of clients doing fintech ventures. It can be costly to obtain a full financial service license or use someone else's, or in the health, if you're creating a health tech platform, does it need to be TGA approved? So that regulatory advice we provide a fair bit of, and it's just something that you should keep in mind depending on whatever it is you're looking to do. Validation and pilot programs, absolutely. We get asked a lot, should I get an NDA signed before I do X, Y, and Z? Guys, you've got to get used to speaking to people about your idea, your venture, unless there's a real it's patented or what. Really, you should be very comfortable with speaking to people about your idea to see, and especially your target market, about your concept to see if it resonates. And I can tell you that we do a lot in that space with startups that are creating relationships with industry partners, etc., to validate their product or ideas. Yeah, at that point in time, there should be an agreement in place. But I think the point I'm trying to make is get used to pitching, get used to talking to people about your idea, because that will give you an appreciation of whether it's resonating. I've spoken to you about go-to-market docs. Fundraising. Okay, fundraising is something that we do a lot. Like, this is a big part of the work we do. So what should I talk to you about here? So there are many means of funding, right? So, yeah, sure. Is it? So there are many means of funding. You can do, so startup funding, you would have heard of safe notes, you would have heard of convertible notes, right? So a safe note, if you're unfamiliar, is an instrument pursuant to which an investor is putting money into your startup, and at that point in time, they're not receiving anything other than a right to convert the money that they're putting into your startup into shares at some later date, right? So there's a trigger that needs to happen. There are equity, there are issues of equity in your company, right? Which is where you're just issuing shares in your company in exchange of money, right? So that's an equity or a price round. When you're dealing with venture capital funds, etc., angels, normally that's how they invest, right? Because they want to exert a level of control over your startup. And when I say that, I don't mean you shouldn't be afraid of that. I think most of most. And then finally, I just wanted to run through what a typical funding round looks like. So at the outset, you should, a key message actually with startup funding is please ensure that you look organized, have your cap table up to date, have your key agreements all in order, etc. Because while that might sound very basic, from an investor's perspective, if you look organized at the outset, they'll want that conversation to keep going, right? So get your pitch deck ready, update your cap table, your founder team, have your roles and responsibilities. We've seen, it's an isolated example, but I'll give it anyway. It was an oil and gas-based venture technology that created for working out how to decommission certain assets in the oil and gas sector. These guys threw away what was going to be a $5 million funding round, where we were basically close to signing because the founders were just so disorganized in that final, when we were looking to negotiate the subscription agreement and the like. When we were there, but they were having a bit of an infight between them on a Zoom call. It just went to crap. I still hate that story because I just feel like they throw away a real opportunity. So just make sure you're quite clear in terms of your roles and responsibilities with the founder team. And please, in pitching, talk about yourselves. In the startup landscape, people are investing more than your idea. They're investing in you, they're backing you. So talk about yourselves, tell them a story, tell them about why you are the best team to work on this idea. Get your advisors sorted, whether lawyer, accountants, corporate advisors. If you're advised properly, look for people who understand market norms is my key takeaway there. I think you'll get people who can do the technical work, but market norms are really important. So from there, there'll be a level of due diligence that happens on your venture where an investor is going to want to see, they might look to stress test the code, the technical, the technology you've created, obviously your business plans, your financial modeling, your key agreements, etc. This is the point in time that you should be having people sign NDAs. You shouldn't be sharing commercially sensitive information about your business without an NDA signed, right? And normally at the time they're doing due diligence, there would be a term sheet getting negotiated with investors where they will be starting to talk to you about on what basis will they invest in your company, which will lead through to legal documents. This process can take 6 months to 12 months at times. You can do it quicker. And I know that it's surprising, but we see that startup funding it's not a quick thing. So be aware of your how quickly you're burning cash. And this should always be something you have an eye on. Who are the investors that are likely to be interested in your startup? A lot of the VCs these days have very publicly available the industries they like to invest in, the stage of business they like to invest in. So have a hit list ready to go and be proactive, right? It does take time to close a funding round. It would be my. And you want that time so you can create a bit of competition in the market as well. You don't want to be stuck with one or two options. And that's it. So I know I've rattled through it quite quickly. I would normally spend a bit more time explaining all the various topics, but I hope that's given you a bit of a flavor of the sorts of things you should be aware of as founders.
Thank you, Rahul.
No worries.
Thank you. Rahul, can I ask you to come a bit forward, please?
Oh.
Okay, just FYI, all the slides will be shared with everyone, so you'll receive them in the upcoming newsletter. But I love seeing all the photos taken of all the slides. It's proof of the session and how important this information is. I'll give you the mic for questions. So it's not connected to the speaker, but it is recording for the online recording. But yes, please, questions.
Thank you for the. Is it working?
It is working.
Okay. Yeah. Thank you for the informative session. I've just got two questions. So firstly, I'm wondering, say for employees who are interested to take some shares, I'm wondering sort of how to kind of arrange that and whether we need to sort of follow the minimum wages and the legal requirements for that. And the second question is, like, say if we're planning for international expansion, how do you sort of approach that step by step? And do you need to get trademark for every country at the start, or should you normally take it sequentially?
Yeah, okay, good questions. So in terms of
Sorry, no worries. So if you just want to...
So he was asking about employees at the outset, the obligation to pay a minimum wage, and then you were asking about how to incentivize them with equity and ESOP arrangements, and then to the extent you're looking to expand internationally, what the strategy should be in relation to trademarking, right? So at the outset, in terms of if it is a genuine employee, look, you are bound by the laws, employment laws, right? So keep that in mind and do consider whether there is the ability to have, do you need to be onboarding them on a full-time basis? But if you are, yes, there is that requirement. In terms of incentives, as I said, there is a startup-focused employee share plan that's available, right, where you normally end up issuing options in the company, options to acquire shares in the company to people that you're bringing on. And the reason that's advantageous for them, because they don't have to pay anything on day one for options, right? There's an exercise price that they have to pay eventually to exercise into shares, if you're following, but they don't have to pay anything. It's a right to acquire shares. It's good for you as well, because as option holders, they don't get on the cap table and they don't have any decision-making rights at that point in time. Does that make sense? In terms of trademarking, so Jean Calamar is our trademarking expert. So you obviously have a trademark in Australia, I assume, I don't know. But okay, so you would trademark in Australia. There's a system, it's called, under the Madrid, it's called a Madrid Protocol, where once you have a trademark registered in Australia, there are a bunch of countries where you can take the Australian trademark and register it overseas. And most countries, most sophisticated countries are on that. And yes, you should be looking at trademarking before you, as part of expanding overseas, especially certain jurisdictions, like China has a first in best dressed kind of policy, where even though if someone trademarks your brand, they have the first right over it. Whereas in Australia, even if you've had a little bit of market time where you've got a business set up, you have been operating under a certain brand, that actually gives you under law a level of validation for purposes of trademarking later. So if you're looking to expand overseas, you should absolutely be looking at trademarking overseas. Yeah. It protects your brand, so yeah.
Other questions? Yep. If you would like to just stand up and project, please, that would be great. Thank you. Otherwise, we can...
Yeah, I think my question was kind of following on from trademarking. It's like, how does intellectual IP work globally? Because I've worked making content in Australia that's protected under Australian copyright laws, but then as soon as you put something on the internet, how do you protect yourself globally?
Yeah, so when we engage with a platform like whatever, you're buying something via an e-commerce site, that may be based in the UK, it may be based in US, it may be based in Singapore. So the terms and conditions you're accepting as part of that purchase, those are the terms and conditions pursuant to which you are engaging with that company. So it is pursuant to those terms set out, the basis on which they're selling you something, or you're able to download an app, or whatever it may be, right? So if you're setting up a venture here and you've got an online platform, say, and there are people engaging with you from overseas, your Australian governed terms and conditions are how you would enforce your rights against them should they ever breach that contract. Now, enforceability and how practical that is, that's a separate issue, but does that make sense? And the different, here I'm talking about your actual, I'm talking about the utilization of your online platform. If you're talking about your brand in particular, say your trademarks, your logos, etc. Sorry, your logos, your business name, and those sorts of things, that does need to be registered to be protected. So if you've got a business name or a logo, that is a form of intellectual property that only gets protection when you register a trademark over it. And you have a trademark in Australia, then you would have to register in other countries that you're looking to operate in. Yeah. Does that make sense?
Thank you.
Yeah.
Other questions? Yes? Project, please.
So I'm just going to make it easy, just a yes/no question, answer, sorry. So can a smart contract be a shareholder legally of a holding company? And if no, without being represented by a physical entity, just a shareholder by itself?
I understand the question. I don't want to answer that as a yes, no. I will come back to you.
Okay.
Yeah. Seems like it's a question after the session. There's a lot to say, probably. Do you mind projecting, please?
Yep. Question, what sort of legal costs, like ranges would, like a founder would expect at maybe different stages, like when you initial starting the company, maybe like as for the stages, if you can speak on that?
Okay, so to set up a company, it costs circa $700, $750 if you do it yourself. If you go through an advisor, it'll cost you about $1,000, okay? Shareholders agreements, depending on how many founders, etc., you should be budgeting somewhere between $1,500 and $3,000 for a shareholders agreement. An ESOP plan, as and when you start to onboard people, I'm giving you up, right? But anyway, it costs about $3,000 to $3,500 to put in place an ESOP. It's a forward-looking arrangement, so you use that moving forward to onboard others as well. Contractors agreements, employment agreements, $1,500 a pop. Again, it's a forward-looking document, so if you get a template, you can then use it to onboard others. Trademarks. You're looking to register a trademark over a business name, for example. If you're going through an advisor, they'll probably charge you $1,000 for that service, plus the registration fees. So what I would suggest is, as part of setting up a venture, you should probably have a budget of somewhere between 3 and 5 on just to get your legals sorted. Yep.
Yeah.
Yep.
Thank you. Other questions? Yep. Again, please project your voice.
I'm in the AI space. Just a question: if I send like a demo video to like a company on LinkedIn, for example, just like demonstrating what my product service can do, and in that demo video, it includes like that company's name and maybe some brand visuals and identifying sort of features or whatever. Should I include in that demo video or in the copy below it or above it or whatever, just some sort of like disclaimer saying, we're not partnered or connected with this business at the moment, just in case that video leaks out and then all of a sudden they sue because they think that we're pretending to say that we're already working with that company or something like that?
Yeah, I mean, look, commercially, whether they would do that in any case, they'll probably send you a cease and desist and say stop doing it. If a disclaimer like that is helpful, I think, yeah. But I think, yes, a disclaimer like that is helpful. Yeah, you should do that.
Hi, thank you. Great talk. Really appreciate it. I'm curious whether you're familiar with the slicing pie structure in terms of like distributing equity among early contributors and co-founders.
Am I aware of it?
Yeah, or what do you make of it?
Can you elaborate?
The idea that like as people are working, they're achieving milestones, they're putting in hours, and their options like adjust based on exactly what they're contributing in a way that's calculated dynamically rather than sort of a fixed vested schedule.
Yeah, so the issue with that's fine. And I don't have the issue with that is structuring that tax efficiently as well. So when you say that that's the problem, because you do need to give a person, for it to be an offer which makes sense, they do need to have a number of options that vest in their favor, or you could do that on an ongoing basis. I agree with it in theory. Any options or equity that you're giving to anyone, we always put in place a vesting regime, which is KPI based or time based or something, right? To make it fluid is workable. We don't see it as much in theory. One of the reasons being, in practice, one of the reasons being, I do think that there is also value in simplicity, where people have a clear idea of how their options will vest and what they need to do. I think it does create an ease and that's commercial. If I hit these targets, I'll get this much equity. It's certain. It's for those reasons. In terms of if it's a fluid structure and there's a lot of movement up and down, the drafting can be a little bit complicated, and then how do you make that tax efficient? I'm sure there's a means to do it, but that would be the only issue. Yep.
Thank you.
Have I understood that correctly, though, your question?
Roughly.
Yeah, so you're talking about a dynamic means of, so does that mean you're also clawing back at times? I assume you would be.
So this is like a structure that I've done online, but maybe too complex.
Yeah, no worries. Yeah.
You're welcome to have a chat about it a bit later. Yeah, please do. Got a question from Bart?
Hi, so my company is going to be brilliant and worth $1 trillion life revenue, right? It's fantastic. But the problem I have is that I'm very budget conscious. Taking donations if anyone's interested. But basically I have 3 patents that I need to secure, but I want to do them all myself. So rather than pay $350,000 to a patent attorney, is it legal for me to construct that patent and do most of the work myself? And is it legal to do it that way, or do you have to go through an attorney to make it proper and legal?
No, you can do things yourself. I'm not a patent attorney, by the way, but whether you're eligible and whether you are going to be doing correctly, that's a separate issue. But yeah, absolutely, you can do.
And I guess they'll tell me if it's not correct.
I appreciate that, but given, yes, you can do it yourself.
Okay, well, that's great.
No worries. Yep.
Thank you. I'll take one more question. Yep, Chris.
I don't think the mic's working.
Yes,
It's recording.
Oh, it's recording. Okay. NDAs with universities. Some of them, when I see the terms, they look unenforceable, unconscionable. How much can you challenge them?
Do you mean because they have? Are you talking about the restraints that are in the NDA?
Yeah.
As opposed to because confidentiality obligations per se are fine, and you have them, for the obvious reasons that people don't share more broadly. But are you talking about the restraints? Is that what you're referring to?
I think
in terms
the
of restraints of trade.
Yeah.
So restraints of. There's a lot of grey area with restraints of trade, and it's our restraints. A reasonable restraint is enforceable, right? An unreasonable restraint would be considered anti-competitive and not. So when you talk about, I don't know the particular circumstances. You can't answer that as a yes or a no. You would see that there are these things called cascading clauses with restraints, where if I will say to you, you can't compete with me in Australia. If Australia is unenforceable, then Victoria. If Victoria is unenforceable, then it's Melbourne. So you kind of draft them in a way where a court, if it ever got to that stage, is able to decide what is how should I enforce this restraint.
Also the intellectual property side.
In terms of what about the IP side? What do you?
Well, if you, I guess, under an NDA, you're sharing some of your IP or what you're about to do.
Yep.
With the idea of future partnering agreement.
Yep. No,
Quite restrictive in.
So yes, there is absolutely they're enforceable. So if you're talking about intellectual property and how the intellectual property will then be deemed to be owned by each party, that was my point, that it's critical that you understand before you sign up, because we've seen a lot of clients where they will enter into arrangements with a university, but where the standard form university agreement provides that the IP that is shared with them belongs to them. Now, I don't know if they're doing that intentionally or whether there's someone in the commercialization team that just flicks out a document, but gee, it's a problem. Yeah, so in terms of what should happen, the document should say that we all have our own background IP, that anything we bring to the arrangement belongs to each party, and then any enhancements, right, really should belong to you as the founder, so you can take it away and commercialize it, and the university should have a license to be able to use it for teaching, right? Because that's what universities do. So that should be the form of regime that's put in place, but yeah.
Yeah, I'm talking about that, and also the power imbalance where it's like, I don't like that clause, can I just delete it or cross it out? Do you have much success in that?
Yeah, we do. Yeah. In fact, we're doing a fair bit of that now. Yeah, and it does help to have a legal partner in place with that sort of stuff. Yeah.
Thank you. I've got a question that I need to ask. It's from online registration, but it's a good question. Any legal competitive modes in the AI space, and any risks?
Any legal, sorry?
Any legal competitive modes. So currently, there's this big conversation with AI.
Yep.
Investors are looking for modes around just, spinning off AI products. Are there any legal competitive modes to bear in mind in the AI space?
I don't.
Things, maybe competitive advantages in setting up your legals in the AI space that could potentially protect you, differentiate you, or establish some kind of moat around your business.
In the AI space, are you talking about in terms of being able to utilize something that's available, readily available in the AI space that will help you get up and going quickly?
Sure, potentially.
They normally end up targeting. There's stuff like our friends are creating there with the with the R&D incentive. So there's a lot of that sort of stuff that we're seeing. Is there anything that's coming to mind where it's targeting lawyers? Sam? Do you?
I think the international, but Legora, I think Legora is UK and Harvey, I think is US.
Yeah, but a lot of those sort of, so we've got Spellbook, Harvey, but those normally target law firms.
Yeah,
That's why I'm not able to. Yeah, something that's actually being targeted to founders to set up. There are certainly platforms.
There is some for coding. I know that there's 2 or 3 like AI platforms that help you code and develop software.
No, but in terms of legal, anyway, yeah,
It's potentially a bit of a vague question, so that's okay. We're going to wrap up the session. So thank you all for coming in, and a round of applause for Rahul again.
Thank you. Cheers. Yeah.
Okay, I know that a few more of you had some questions. You can always come up and ask questions, but I also have some exciting news. So Allied Legal, so we'll be sending you a link in the email with the feedback form. Allied Legal will be providing one-on-one support sessions for you. So we'll be sending you that link. If you want to have one-on-one conversations with the team, you're more than welcome to do that then. We'll also be putting up a couple of QR codes on the screen if you want to register for the Lunch and Learn event or apply for the Business Fundamentals program. But now we'll break back into networking. If you have any questions to Rahul or Sam, please come up. Otherwise, please connect. The event concludes at 10 a.m. Thank you all. Thank you.